Hello, everyone. This is Frank Wu speaking. I hope you can hear me. If you have any issues, you can access a question box through the webinar app, and you can go ahead and ask a question. So if anyone is already there in the question box, if you just type "I can hear you," that would be great. So we want to make sure this is working. We'll have some other people joining. I'm only going to speak for about 1 minute at the beginning. I'll go ahead and start. So as I said, my name is Frank Wu, and I have the honor of putting this together with SCBA. I'm a law professor and will become the president of Queens College shortly. And I'm joined by two experts who are colleagues and friends named Paul Thaler and Shan Wu. Despite the name, Shan and I are not related. We are not cousins. But they're just terrific speakers. We will leave time for all of you to ask questions. You can type them at any time, and I'll moderate. I'm just going to say a few things at the outset. Let me introduce Paul and Shan. They're lawyers with a firm in Washington, D.C. You probably already know this from what we sent out or from looking at their bios, but I really want to tout their credentials and experience. Paul is one of the leading lawyers in the United States representing specifically professors. It's a very specialized area, and he's represented dozens, I think actually hundreds of professors on issues related to research. So he specializes in that in every aspect, from the research integrity issues to the employment issues. He's what would be called a lawyer who does civil work. Okay, his law partner, Shan Wu, is what's called a white-collar criminal defense lawyer. Well, white-collar means he doesn't do violent crimes, and he defends people. He is a former prosecutor in Washington, D.C. That's very important. So he's had experience with the government. He actually served in a high-ranking role in the United States Justice Department as well. And Shan has represented many different people facing every type of white-collar charge, and he also has done a lot of work on university campuses in the Title IX area. So Paul does the civil work, Shan does the criminal work, and they very graciously said that they would present to you. I'm almost done. Just a few preliminary items. They are not becoming your lawyers now, and I'm not becoming your lawyer either. However, if at the end of this you have a specific set of concerns, we'll put their contact information up on the screen. You can contact them and talk to them. And part of what we're going to guide you through is how do you find a lawyer, how do you work with a lawyer, as well as why you really need to get a lawyer as soon as possible. But if you're interested in talking to Paul and Shan, this is an educational webinar. It's not a sales pitch. But at the end, if you're interested in contacting them directly, you'll see their information then. You are all muted, but you can ask questions using the app. When you ask questions, you should not talk about anything confidential about your particular case. It's just that's how a good lawyer will handle this. You don't want to disclose anything, even if you think you know some of the other people on the call. Okay, and this call has a range of people on it. Shan and Paul will have a few more words to say just as preliminaries. And note, we are recording this so that other people can listen afterward. We have more than 100 people on the line. But others have expressed interest, so just terrific to see so many people who want to learn. This is, I know, a difficult time for many reasons, both because of the issues we're talking about and the coronavirus crisis. I'm going to stop there. I'm going to turn it over to Paul Thaler. And again, if you have any questions, go inside the app and write the question. We're going to leave plenty of time for Paul and Shan to answer questions. Paul, over to you.
Good afternoon. My name is Paul Thaler. My law partner Shan Wu and I are pleased to present this webinar on the subject of how scientists should handle various forms of investigations into allegations concerning their research. Shan and I are both partners in the Washington, D.C. office of Cohen Seglias, Pallas, Greenhall, and Furman. I would first like to thank you, Frank, our facilitator, and the SCBA for allowing us to make this presentation. By way of professional background, for almost 30 years, I have represented many hundreds of scientists across the United States and internationally when they are faced with allegations of research misconduct. Additionally, I have assisted dozens of institutions throughout the country in managing such investigations. My presentation will include explanations of what these investigations are, the processes and recent developments, especially affecting Chinese and Chinese American scientists. I will first address what you should do when the university is knocking on your door. After that part of our representation, Shan will explain what to do when the FBI or police are knocking on your door. And we'll be happy to take some questions at the end. So to begin, what to do when the university is knocking on your door? Essentially, there are two major concerns for scientists when they are being investigated by universities, typically their employer. One is in the area of research misconduct, allegations that concern fabrication, falsification, or plagiarism related to their research. And I'll explain what these mean shortly. The other area, especially most recently, concerns conflicts of interest, typically financial conflicts of interest, and also conflict of commitment. Again, I will explain these areas in just a second. So what is research misconduct? Research misconduct is governed both by federal regulations as well as your university or hospital policies. Each university and hospital has their own set of policies, and they are guided also by federal regulations, especially when federal money is being used for research. The process for determining whether scientists or researchers engaged in fabrication, falsification, or plagiarism will be explained in a few minutes. Research misconduct inquiries and investigations are conducted by the universities themselves or hospitals on behalf of the federal government when federal money is involved. And if no federal money is involved in the research, then they will have their own policies that they will adhere to in conducting their internal investigations. So then, what are the types of research misconduct? Typically, what we're focused on in research misconduct allegations are three types. One, fabrication, and that's making up data or results and recording and reporting them as if they came from your research. The second is falsification, which is essentially manipulating research materials, equipment, or processes, or changing or omitting data results such that the research is not accurately represented in the research record. So that's when you've done some research and there is an allegation that you manipulated that research to reflect a different outcome. Plagiarism is the appropriation of another person's ideas, processes, results, or words without giving appropriate credit. Here, this is a little bit different than in ordinary common law plagiarism, where it's typically an allegation of a copyright infringement. In those cases, ideas are not typically allowed to be considered in making a claim. But here, in research misconduct allegations, it can also include the appropriation of another person's ideas. The requirements for a finding of research misconduct. In addition to making a finding of fabrication, falsification, or plagiarism, a finding of research misconduct requires, at the end of the day, by the university or hospital conducting the investigation, significant departure from accepted practices of the research community, a finding of a level of intent. The misconduct must have been intentional, knowing, or reckless, and that the result is found by a preponderance of the evidence, that there is proof by a preponderance of the evidence. Note that this is different from other kinds of levels of proof, and you'll hear about that as I discuss the investigation stages, but there are other levels of proof. Preponderance of the evidence is essentially more likely than not that something happened, just slightly more than 50%. Both federal regulations and typically university and hospital policies allow for honest error and differences of opinion. They are not research misconduct. That simply happens in science, and if that's what happened and the university or hospital determines that that's what happened in that particular case, then there will be no finding of research misconduct. What is a conflict of interest in this forum? What we're seeing now is allegations of different kinds of conflict of interest, one being financial conflict of interest, essentially receiving compensation from an outside entity while you're working for your home university or hospital, and a conflict of commitment, agreeing to dedicate your time to an external entity. Both university policies and federal regulations require disclosure of actual and potential conflicts of interest. What the university or hospital and you should look at would be your contract. Typically, research scientists have some form of contract with their university or hospital. Also, faculty handbooks should be reviewed, as well as federal regulations. University policies will generally apply to all employees. That's one of the reasons why you want to look at the university handbook. Federal regulations apply when scientists, researchers, or other scholars seek and or obtain federal grants. It's important to note that you can have a problem, meaning an allegation of research misconduct, even if you just merely seek a grant and don't even get it. If you make that application and there is determined to be misconduct associated with that grant proposal, you can still have a problem either with the federal government or your university. Recently, there's been increased government scrutiny of actions being taken by scientists in the United States along these conflict of interest concerns. In August of 2018, NIH Director Francis Collins issued a statement of protecting the integrity of U.S. biomedical research, expressing 3 areas of concern: failure to disclose resources from other organizations, including foreign governments, diversion of intellectual property, that's IP, to other entities, and sharing confidential information with foreign entities. This was followed up in July of 2019, just last year, by the NIH, which issued notice NOT-OD 19-114, reminding grant applicants and recipients to disclose all resources and other support, regardless of monetary value, any foreign component, and financial conflicts of interest, including financial interest received from foreign entities. It appears that people from China and Chinese Americans are targets. In practice, NIH is focusing on affiliations with China, particularly connected to the Thousand Talents program. Most, but not all, of the matters being investigated involve ethnic Chinese scientists and Chinese Americans. NIH has investigated at least 180 scientists from more than 65 institutions for policy violations related to foreign ties. 21 cases have been referred to the HHS OIG for debarment. This would be a prohibition from receiving federal grants for research. Nearly every scientist under investigation is well-funded and established. NIH is working closely with several other federal agencies, including DOJ, FBI, State Department, and DHS, that's Homeland Security. Here's a quote from the NIH Deputy Director for Extramural Research. Dr. Thaler said, "This is not xenophobic racism, this is not targeting, and this is not stigma, this is real theft." And what he means is the intellectual property concerns. As we've seen in our practice, a dramatic uptick in the number of allegations being raised against Chinese and Chinese American scientists conducting research here in the United States, and the allegations concern conflicts of interest. Let me jump back to stages of misconduct proceedings. Most universities follow the following process. First, there is an allegation or several allegations made concerning research. These are either made directly to the university or hospital, or if it's federal research dollars, it could come from the Office of Research Integrity itself, part of HHS, and referred then to the university or hospital for investigation. There's an initial review and assessment, typically by the Research Integrity Officer of the hospital or university, to determine whether there's anything there that might be research misconduct. If it appears that it's possible there could be research misconduct, it goes to the next stage, which is typically conducted by a committee of people from the university, your university colleagues, usually other professors, on a committee called the Inquiry Committee. It's the job of the Inquiry Committee to determine whether there's a prima facie case to be made for research misconduct. What I mean by that is it possible that there might be research misconduct? That's their task. If so, then it goes to investigation, which is another committee, the Investigation Committee, and at that point, there's the preponderance of the evidence standard that I referred to earlier, which is essentially, is it more likely than not that there was research misconduct? The Investigation Committee will conduct interviews of witnesses and review data collected to help it determine whether or not there is research misconduct. There are other avenues to pursue. If you get a negative finding at the investigation level, there's usually appeal, and then ORI itself will receive the report from the university to make its own determination, and you can pursue a discussion with ORI to determine whether or not there is research misconduct and advocate for yourself. Conflict of interest issues do not follow the same strict, in-depth process and varies based on university policy. It's typically managed more as a focus on the scientist as an employee of the university or hospital and his or her obligations to the university by policy, contract, or statute. You should keep in mind the potential exposure to you of an allegation of research misconduct reaching a final negative decision. Research misconduct findings can result in various actions, including but not limited to corrections or retractions of published works, journal corrections, sometimes retractions, employment action up to and including termination. And this is why it's important to determine whether or not you are tenured, because you have certain additional rights as a tenured member of the faculty versus a contract employee or professor. Imposition of supervision or assurance requirements, suspension or termination of a federal grant, and suspension or debarment from obtaining federal funds. The last potential action is typically handled by ORI itself. If it's going to be a decision that you should be debarred from receiving federal funds or make an application for federal funds for some period of time, that will be up to ORI. Findings of conflict of interest disclosure violations can result in various actions as well, including employment action, up to and including termination, and criminal charges. And Shan will discuss some of those during his presentation. Here are a few cases that we've seen over the last year and a half. For example, a Chinese-American tenure-track professor was accused of research misconduct by his department chair. Although there was no finding of research misconduct, there was a non-renewal of contract despite lack of finding. Now, the important thing here is to remember that this is different from if that particular professor had been, in fact, tenured as opposed to tenure-track. He was not yet tenured. He would have had additional rights had he been so. There was a former graduate student accused of research misconduct in his thesis. There was a finding of research misconduct and a recommendation to revoke his doctorate. We saw a tenured department chair have a no finding of research misconduct against him, but findings of research misconduct against other members of his lab. He was the PI. Nevertheless, there was a permanent restriction of research privileges, despite there wasn't a finding against him himself. We saw a Chinese-American tenured professor have criminal charges of wire fraud for allegedly submitting false conflict of interest forms. There were criminal charges of program fraud for allegedly receiving federal funds, while also employed by a Chinese institution under the 1,000 Talents program. We saw a Chinese-American tenured professor in a case in which the university made findings of conflict of interest violations based on affiliation with Chinese university recommended by another professor at the U.S. institution. Despite this is a case where they found violations, but the university agreed that the actions did not rise to the levels necessitating sanctions. And finally, there was a department chair indicted for participating in the 1,000 Talents program and allegedly lying about his affiliation. There are some common misconceptions with regard to the use of lawyers. One is that some scientists believe that the university or their colleagues can help them through the process. You have to remember that the university has its own interests and obligations, and your colleagues have obligations to the university that might be separate and distinct from your own. Additionally, the university might be feeling pressure from governmental agencies. It's important to remember your interests are not necessarily aligned with the university and your colleagues. There's another misconception about hiring a lawyer that will make the university think that I want to sue the university. Well, the university general counsel, the GCs, are savvy enough to understand that people hire lawyers when there are threats to them. Here, in these cases, your career and reputation are at stake, very serious matter. You've worked for many years to develop your career and you have a reputation to protect, and that's a perfectly reasonable reason to hire a lawyer. General counsels at universities and hospitals understand that. Another thing that we see is scientists reaching out to a local lawyer who might be an employment lawyer or a civil litigator, and they say that the scientist doesn't have a case against the university. Well, this is a very distinct type of concern, the research misconduct allegations. It's not the same same type of case that employment lawyers or civil litigators see, and it's best to find someone who understands the process. This is not the sort of case where you will have claims, at least at the outset, against anybody. You're defending yourself. Keep in mind also, lawyers who handle misconduct cases have to charge by the hour for their work. There can't be a contingency fee because you're not pursuing damages. So how can a lawyer help you? Well, we can provide guidance and advice on what to say and how to say it. We can do so in the background, which some scientists prefer, that we not make ourselves present, or by more actively participating directly with the university on your behalf. We can assist you in providing comments on draft and final reports and other submissions to the university and to ORI itself to present your case favorably and to protect the record. One of the most important things that we do for clients, and this is both for scientists as well as universities, is to ensure that the proceedings follow the proper process. This is important because if it's the university, it's exposing itself to claims by scientists later that the university did not adhere to the proper process. But if it's the client, you want to make sure that the process is followed so that your reputation, your career is protected. You have confidentiality protection throughout, unless and until there's a negative finding. And the next point about reputation restoration is if the university does not properly protect the process, then the scientist who is exonerated at the end can go back and require the university to take steps to restore his or her reputation. And finally, there are various times during the course of these matters when a lawyer can help try to resolve it by settlement. So at this point, I'd like to turn this over to Shan.
This is Frank. While Shan is getting ready, I want to highlight something Paul just said. Probably every one of you on this call needs at least an initial consultation with a lawyer, which doesn't mean that you have to hire them for years to come, but I'll give you a very simple test. If you have any U.S. federal grant at this time, and if you have ever had in the past or now any title, position, grant from any Chinese government or university entity, you need to at least have an initial brief consultation, even if you believe you've done nothing wrong. I have had many conversations, and I refer folks to qualified lawyers such as Paul and Shannon. By the way, if you talk to me, it's pro bono. I get nothing for referrals. There's nothing like that. And I can tell you, 100% of the people who contact me need to have a consultation, and most of them should have had the consultation months or even a year or more earlier. So I just wanted to add that. Shan, I also wanted to give you a moment to get on the line.
Okay, thank you very much, Frank. Hi, folks, this is Shan Wu, and I'm going to talk a little bit about the difference between the civil type of issues and investigation that Paul had discussed, typically with the university, versus criminal ones. And when I have taught, one of the things I usually give my students as a very simple way to know the difference is in criminal cases, the concern is people may go to jail. And that's not the concern in a civil case. So that's the easiest way to remember it. I want to say at the outset, you talk with me that although my parents are from China, I was born here. So my Mandarin is very poor. It's like a little kid's Mandarin. But one thing I do remember is a phrase my dad used to say, which is if things were very stressful, that in Chinese you'd say, 很伤脑筋, it's very stressful. This type of case, this type of issue is very, very stressful. And it's particularly stressful because there appears to be very much a focus on Chinese people and the country of China. And I'll say at the outset that although there are statements such as the one we saw on Paul's slide from the NIH director that the administration, meaning the federal administration, the Trump administration, says that this is not racist or anti-China, there's a strong feeling that it is. But for our purpose, for our job as lawyers, that's completely irrelevant. If you come under investigation, we are not going to get any place debating the policies whether right or wrong, of the United States. We will get someplace by focusing on the particular facts of your case and how the particular laws may apply to it. So if we look at this first slide, here are the major concerns. There's something called a China initiative that the Department of Justice, that DOJ, that's the abbreviation, has started. And it specifically looks at Chinese nationals, Chinese Americans, contacts with China. And they look at the university issues that Paul had talked about. And then from there, simultaneously, they may look at criminal issues, such as the primary basis of prosecutions, fraud claims, or crimes against the United States, which we'll talk a little bit more about. Typically, when there are criminal charges, they usually may include theft of intellectual property, wire and mail fraud. It often ends up being only the wire and mail fraud, and we'll explain why in a moment. But these are terms that you may hear, and so we just want to cover a little bit of what they are. So I can get to my next slide here. Okay. What is the Department of Justice's China Initiative? And they explain it this way. It's identifying and prosecuting means bringing a criminal charge, those engaged in trade secret theft, hacking, economic espionage. It focuses on protecting the United States' critical infrastructure against external threats, combating covert efforts to influence American public and policymakers without proper transparency. Very, very broad, but also very, very targeted, obviously, on Chinese people and contacts with China. It began in 2018, specifically after a U.S. trade representative had issued a report basically on how China's economic aggression threatens technologies and intellectual property. It didn't only start then. There had already been pretty rigorous scrutiny of a lot of these sorts of issues previously, but the initiative really launched in full-blown fashion post-2018. This statistic is very important to understand how serious this is. According to the Department of Justice, about 80% of all economic espionage prosecutions brought by DOJ allege conduct that would benefit the Chinese state. There's at least some nexus to China in about 60% of all trade secret theft cases. So obviously, an enormous majority of what they're doing criminally with these types of issues focuses on China and connections with China. That is a way of echoing what Frank said, that if you have any connections, any dealings with Chinese entities, the Chinese government, you have to be just very aware of the fact that they may be scrutinizing you for that. Within DOJ, where I used to work, is the National Security Division. And we usually hear about them because they're responsible for terrorism type issues. And it's defined as countering nation state threats to the United States. That's just important to know as background, that this gets a big emphasis at the Justice Department because it's considered a national security threat as opposed to simply intellectual property or perhaps a failure to disclose information. They treat it as the category of the most serious types of crimes or offenses. So these are the guidelines that have been set by the Justice Department. The Attorney General, that's the head of the Justice Department. They're looking for trade secret theft cases, and they've tried to develop a general enforcement strategy concerning, and you'll see what they call here the non-traditional collectors, researchers and labs, universities, as well as defense industrial base. And they're very concerned about the transferring of technology or technology information. They're also trying to generally educate colleges and universities about these potential threats. That probably has led to this big influx of issues that Paul has encountered, because universities and colleges are very on alert for this now because the Justice Department is looking at it criminally. And they also seek to apply a law called the Foreign Agents Registration Act. And that's where if you're determined to actually be working as an agent for a foreign country, lobbying, whatever else may be involved, then you're supposed to register. That used to be a law that was very rarely used and very rarely went criminal, but recently, since if you may remember this, the Mueller investigation about the Trump administration's activities, that law has been sort of revitalized, and they're being much more aggressive with that law now. And then lastly, they want to equip the U.S. attorneys in the nation with intelligence and materials. So the U.S. attorneys are the federal prosecutors assigned to each jurisdiction in the United States. So that's what they mean by U.S. attorney, as opposed to someone who works for the particular state that you may be in. The important point here, besides the Foreign Corrupt Practices Act, which is another federal statute typically involving giving bribes, is there's also a lot of efforts to improve coordination with China under something called the Mutual Legal Assistance Agreement. These MLATs, as they're referred to, are just where the country-to-country law enforcement people are speaking and coordinating with each other. There's a lot of interest in this issue in Congress, and that last bullet point, additional legislative and administrative authorities. And so there's very strong support for this in the U.S. Congress as well. What are the typical criminal charges? Mail fraud, wire fraud, program fraud, false statements, conspiracy to defraud. Let's start with the mail fraud and wire fraud. These quite simply mean that if you utilize the U.S. mail, if you utilize the wires, meaning internet, email, any kind of communication nowadays, that if it's linked to a criminal case, can subject you to the mail and wire fraud charges. Program fraud sort of speaks to itself. You're alleged to have committed some kind of fraud against a program. False statements, another very, very broad charge, which is if on any part of the documentation that you're making, there's something that is wrong or something that's omitted, you may be subject to being charged with false statements. Conspiracy to defraud the United States. A lot of people think of conspiracy as being something quite complicated. A lot of people, criminal drug cartel, something like that, does not have to be. Simply communicating with one other person about something, they can charge conspiracy. So that's, again, a very broad tool that prosecutors like to use. Just to go over some of the basic understandings of what mail fraud and wire fraud need to be proven, the standards beyond a reasonable doubt. You have to intentionally defraud another by making materially false representations or promises. Critical word there is material. Lawyers will argue a lot about that. When you have a defense lawyer, one of the things we're arguing about is whether the law actually has been met by the facts in your case. So the word material there means it has to be very important. It's got to be a central false representation. Making a mistake that is rather small, the misspelled name of your street that you live on or something like that, that's not going to be material. The rest of it, all up for grabs. The defendant must intend to defraud. So it's got to be intentional. It can't be accidental. Again, a big area of debate between your lawyer and the prosecutors. When I was prosecuting, one of the ways we like to define the difference between a white-collar crime versus a violent crime is in a violent crime, someone gets robbed, someone gets shot, even murdered. It's a who done it, who did that crime. In a white-collar crime, the big focus is on, was there a crime? And that's what we're debating. My client did this. They're doing work under a grant with the Chinese university. We're not debating if they really did that or if they're the people that are doing that. What we're going to debate with the Justice Department is, was there anything wrong about that? Was there anything criminal about that? Program fraud kind of speaks for itself. It goes to theft or bribery. Note that the use of the word theft is very broad again. I mean, if they feel that you misrepresented something in the program application, they can charge you with theft of the money. It doesn't literally mean that someone is, taking a pile of cash and using it for something secretly. It really goes to whether the information was accurate or not. False statement, spoke about before. It's basically having something that's material or important that is wrong. Also, it can be withheld. If you're failing to disclose something and yet you claim that the document that you filled out is completely accurate, that can be a material false statement. There again, there's a requirement of it having to be knowing and willful. So it's got to be deliberate. It can't be just an accidental type of error. Although, again, that's going to be something which is hotly debated, whether something was accidental or intentional. And really, that goes to how important the fact is. That's going to go a lot towards determining if the government, if the prosecutors think that it's accidental or whether they think that it's knowing, willful, deliberate. Conspiracy, just to show you how easy it is to prove it, the existence of an agreement. That just means we've talked about, okay, we're gonna work together. That's the agreement. An overt act by a conspirator, again, very easy. It can be simply sending the email is the actual action taken upon. Third, an intent on the part of the conspirators to agree. That's easy, as well as to defraud the United States. That's going to be the muddier part. Was there any part of this plan to work together that was trying to defraud the United States? That's where, as a lawyer representing you, we'd really focus on that to argue there's absolutely no intention to commit fraud. So there have been a lot of cases like this, and we'll take a look at one as an example.
Shan, this is Frank. I'm looking at the questions, and I want to encourage people to ask questions. Let me pose a question right now, and we have about 18 minutes left for both Shan and Paul. The question is, will the researcher always know that they're under investigation, either the civil or the criminal, or is it possible that something is happening and they don't even know about it?
Yeah, very good question. I was going to cover that. I saw that come up. Certainly in the criminal case, you can absolutely assume by the time you have been contacted, they have already been looking at this for quite some time. They're not going to tell the person under investigation first that they're looking at this. So you always start off at a big disadvantage.
This is Paul Thaler. From my work, the initial stages that I described earlier, in which the allegations are reviewed typically by the RIO of the university, the Research Integrity Officer, it is possible that you will not know that the allegation has come in, but typically, once it gets past the initial review, and many times at that initial view stage, the research professor will be alerted to it and will receive the actual set of allegations. And certainly by the time it goes to the inquiry committee stage and beyond, you will have a notice of allegations that you are confronted with.
Any other questions we'd like to cover right now, Frank?
No, this is great. Yeah, this is great.
Okay.
There are some specific questions, and for those who are asking questions about particular cases, again, I encourage you afterward, seeing the questions that are coming through, I can tell you, if you're asking a question, you absolutely need at least a preliminary consultation. For Paul and Shan, as you're addressing this, if you could just talk about the need, even if there's a concern. So some people have already left their position. They're wondering if that clears up matters. And I defer to you, but I think the answer is no. There's still a possibility, depending on the details and their new position, of either civil or criminal concerns. And Shan, if you can address, you've done this, but just talk a little bit more about how this is defensive, not offensive. It doesn't mean you're going to sue anyone. And that you, Shan, and Paul, you can both do consultation that's not aggressive, and you don't have to actually surface. If you can explain a little bit about that.
Sure. On the criminal side, this is Shan. I'm going to, I think, advance a couple of slides to where I was going to talk about how lawyers can be helpful, or Paul can advance some. We interface for you as necessary. In a criminal case, it's going to be a little bit rare have to surface because you are already being contacted by the FBI, you're already being contacted by the prosecutors. So you'll want to have the attorney surface at that point to talk with them. What the attorney can do, as we're seeing on this slide, is the lawyer meets and communicates directly with the FBI, DOJ, because you don't want to be talking to the criminal investigators. Everything you say could be used against you, even if they're misunderstanding it, taking out of context. If your lawyer talks to them, that's not the same as you. They can't use my statements to them as evidence against you. We obviously are looking to defend your rights, making sure, as Paul does, that the process is done. And lastly, we negotiate with them, trying to get rid of the charge, trying to lower the seriousness of it if they insist on bringing it. For a criminal case, having left the position won't save you. They will still go after you criminally. And I'll defer to Paul on what happens if you leave the institution and then they're asking you about it.
It's the same answer, Shan, and the interest on behalf of the universities and the ORI, the federal ORI, is to determine whether or not there was mismanagement, mishandling of research money in scientific research, and so that has to be seen through regardless of where the scientist is currently employed. So we've had plenty of cases where there's an investigation being conducted and the professor wants to move on. That's fine, but it won't end the investigation. Or they've already moved on and there's an investigation at their old place of employment. That will go through as well. So the point is simply that movement in your career will not affect whether or not there's an investigation or make it end prematurely. It will be seen through to its conclusion.
May I start? We now have a whole series of questions. If it's okay, because I'm also mindful we have about 12 minutes left. I'm getting some questions about what happens if you're contacted, okay, if you're a professor and you don't want to talk to the FBI or whoever, and does it matter if you're a U.S. citizen?
It does not matter if you're a U.S. citizen. They're going to investigate you either way. If you're not a citizen, obviously there are some potential collateral effects if you were convicted in terms of immigration status. I think they're going to want to convince you to voluntarily speak with them. And this brings me to one other point. Many people, almost most people, feel that if I've done nothing wrong, I'm not afraid of talking about it. That's very natural, makes sense. It does not make sense in a criminal case. They have a very different focus. They're absolutely not on your side. That does not mean that as your lawyer, I'll take a confrontational approach. I mean, I'm a former prosecutor. We talk the same language. We'll make it very collegial. I want to make them feel comfortable that you are being cooperative, you want to alleviate their concerns. But the number one mistake that clients make is trying to talk without a lawyer or not talking to a lawyer first because they feel, I didn't do anything wrong, I have nothing to hide, I should talk to them. Always a mistake to do that, unfortunately.
Here's a related question for both Paul and Shan. If the university contacts the professor and says, the NIH has asked us to talk to you, is it appropriate to assume that that means the NIH has already opened a file on that professor? I think the answer is yes, but again, I defer to the experts. And I'm going to combine that with another question where I'm going to, because Paul and Shan are modest, I got a question about specialties, and I would say you absolutely need someone who knows this area, not a plaintiff's contingency fee lawyer. That's a different type of lawyer. They're looking to make money by suing the university. But Shan and Paul, if people aren't comfortable with you or because you're in Washington, D.C., do you have any tips if they're looking for local counsel where they are? So those are the two questions. If the NIH, if the university contacts a person, should that person assume the NIH has already got something going, and how can they find a lawyer, whether it's you or someone else, who they know understands this area?
Shan, I'll go first if that's okay. On the issue of NIH and the university working together on a matter, it would be likely if NIH is contacting the university that it has something to do with research misconduct and potentially this conflict of interest thing, but more often than not, it has something to do with research misconduct. The point that was being made earlier, the question concerning cooperation is you will have to cooperate if you are currently still working at the university where the research money was used in research. And that's really by virtue of your status as an employee. It's also in your best interest, frankly. And typically, we will recommend that people participate, even if they've gone elsewhere. It's just in their best interest to give the university your side of the story of what happened. There are people who will refuse, notwithstanding the best recommendation to cooperate, and the process will still go on. Your failure to cooperate will be noted, and it typically will not help you. In terms of who you should look to help with representation, best I can say is it depends on what the case is. If it's a research misconduct matter, there aren't many who have that specialty, but you can do a Google search, research misconduct lawyer or scientific misconduct lawyer, and see who might be close to you. The mistake that I see most commonly is people will look locally because they think it has to be someone local. And in these cases, we can do our work here in DC, or you can find another research misconduct lawyer elsewhere, and they can help you remotely. There isn't a court appearance as there is usually in civil litigation or criminal cases, so things can be done remotely. Someone local might have the requisite level of understanding, but might not. So you really want to try to find someone who's specialized. I'll turn it over to Shan.
Yes, I would agree with that very much for the criminal side as well. The ideal criminal lawyer in a case like this is someone who previously has themselves been a federal prosecutor. That's a very small, elite, select group of people nationally. There are many of us, but as compared to total lawyers, not many of us. We can always use our own network. I know many other former federal prosecutors all across the country, so we can help you find someone that's more local to you. This is a national practice because the Department of Justice is national, so it does not have to be someone local, but there are local people. Criminal cases, if things are not going well, at some point you will have to show up in court, and we're able to both have local attorneys who may know the particular court better. We can consult with them, but usually we're able to appear in courts across the country. There's some technical things we need to do that, but you should remember this is a national interest that's going on, and that's why you need lawyers who can practice across the country.
This is Frank. I'm going to combine a whole series of questions. We only have about 5 minutes left, and so Paul and Shan, I'm going to throw all these out. And I'm, again, going to say something about Paul and Shan. They're real experts in many places. If you're in a college town, you will not likely find someone who does this regularly enough to be able to help you. I'll just give an example. I've been a lawyer since 1992. I'm not qualified to do these cases. I know a lot, but these are specialized. All right, three questions, Paul and Shan. First is, what if customs shows up at your door? Customs agents, is that different? Next question, what if the FBI says, don't worry, you're not in trouble, you're not the target? And the last question is, what if you swear you've never actually signed anything with the Chinese government? All right, so customs agents, what if the FBI tells you, don't worry, we're not looking at you, we just want to talk? And then what if you didn't sign anything, though there are cases with people who applied or have honorary titles? So three questions. If you could be real quick, and those of you on the line, please feel free to send questions. We've got about 5 minutes.
Sure, Paul. I'll combine those first two.
Yeah.
It doesn't matter what agency shows up, customs, ICE, anyone. If they are an agent and they want to talk to you, you should immediately have your defenses up. Be very polite, but you really need to speak to a lawyer at that point. Number two, whatever agent it is, FBI, ICE, Customs, reassuring you, hey, you've done nothing wrong. We want to talk to you. Do not believe that. They're investigating something. You need to be careful. That's a classic technique used to get you to be more conversational. So that's me on the first 2 points. Paul?
And Frank, could you please restate the third question?
Yeah, sure. The last question is, what if you never actually signed, you applied for something in China, but you didn't sign? What if you have an honorary title, you weren't paid? I can tell you, my suggestion is still talk to Paul and Shan, even if you didn't sign and you weren't paid, if you applied or if you were a visiting professor, if you've ever received a little red envelope, anything like that. But Paul, Shan, are you okay?
Right.
You applied, then you changed your mind, or if you just did, you have an honorary title.
And that essentially is a piece of evidence. And so the issue is whether or not there has in fact been a conflict of interest, and that would be used to defend yourself. I've seen that in both the civil context as well as criminal context, and it doesn't necessarily relieve you of the allegations. It is a piece of evidence, and it's a compelling piece of evidence, but nevertheless, they can still pursue it, trying to use other evidence to indicate that you did perform pursuant to that contract, even if you didn't sign it.
Yes, I agree with Paul. This is Shan. You don't have to sign something. In contract interpretation, they're looking at the conduct, so the signature by itself, not critical.
Okay. Shan, Paul, if you could wrap up with just 1 minute each, and there is some interest in the Professor Tao case that people have followed that appears in the slides, but we're almost out of time. So Paul and Shan, just 1 minute each, and I'll just add again: talk to a lawyer, even if it's just for half an hour or an hour. It's in your best interest to get an initial consultation. Many of the questions that have come in are great questions, but there are many, many details, and the questions are impossible to answer without details, and no lawyer would answer based on just a little text. So you need to spend half an hour or an hour, and you need to provide the documents. Shan, Paul, 1 minute closing, and if somehow you can work in the Tao case, great.
Paul, why don't you go first? I'll try and work on the Tao case.
Yeah, I'll be very brief because I'd like for Shan to touch on the Tao case as well. So I'll let you have some of my time. I just want to say that this can be a very scary experience to go through. And we understand it, and we've worked with many, many hundreds of scientists, and we can help you through it. But don't despair, because there are protections built into the processes. You do have rights, and if you have an attorney to help you through the process, he or she will help you defend those rights. And ultimately, if you're exonerated, try to restore your reputation. So I wish you all well and stay safe, and I'll let Shan finish up.
This is Frank. Shan, I had a couple questions. The recording will be available. The slides will be available. Watch at the very end. You'll see Paul and Shan's contact information. They are available, and you can contact either of them. They work together at the same Washington, D.C. law firm, and I personally recommend them. I've sent various people to them, and they're real experts. Thank you, everyone. Shan, you have the last word.
Because you'll have the slides, you can take a look at what happened in the Tao case. I think the most important thing I want people to remember is you are not familiar with this world of criminal investigations. Very few people are. Both of my parents were professors, and they would not have thought about any questions as indicating they've done something wrong. You're academics, you're doing genuine work, you're not interested in cheating anybody. But in this climate, if you are contacted by the Department of Justice or your university, you must assume, to protect yourself, that there's already some kind of interest in seeing if you've done something wrong. Once that starts, most people, doesn't matter how smart or well-trained or what degrees you have, won't be able to manage that. It would be like taking a person off the street and asking them to suddenly conduct research in a laboratory in your area. It's a very specialized area, and you need people that understand that to help guide you through it. I agree with Paul. Just because they're investigating you doesn't mean something really bad is going to happen, but it's really important to take the right precautions so that we can help you understand what they're looking at, see if we can make it go away, and fight on your behalf if we have to. But we're not interested in having a big fight with the department, offending people. We're interested in trying to protect you and to make this go away as quickly as possible, and if it can't go away, to make it the least serious effect on your career as possible. So I'll just leave you with that thought.
Okay, many thanks to Paul and Shan. The recording and the slides will be made available for those of you interested in getting them. We will send out information. This has been a wonderful webinar. Please feel free to share it with your colleagues. And again, many thanks to everyone for joining, and another big thanks to Paul and Shan for such a useful hour. Okay, take care, folks. Bye-bye now.